Good afternoon. We want to welcome you to the Tennessee Court of Appeals. The panel this afternoon will be Judge Thomas Frison from my right, Judge Krista Davis from my left, and myself, Judge John McClarty. Madam Clerk, are there any preliminary matters?
No, Your Honor.
In that case, I would ask that you would call the first case, please.
Clata, Renee Brewer et al. Versus Metropolitan Government of Nashville and Davidson County et al.
Have the parties decided or made an allotment as to the time, your time for rebuttal?
Yes, Your Honor. With the court's permission, I would reserve 4 minutes for rebuttal.
Will there be one argument or two arguments from your side?
Only one argument, Your Honor.
Okay. And ask the question from the appellee, how many arguments?
You will have 3 arguments, Your Honor.
Have you divided the time?
Yes, Your Honor. 5 minutes each for myself, Mr. Osborne, and Mrs. Fox.
Thank you. Okay. If there's no preliminary matters, then you may proceed.
May it please the court, my name is Paul Krogh, and together with my various co-counsel, I represent the petitioners in this case. The TPRA creates a simple, unique, and expeditious process for adjudicating public records disputes. That process leaves no room for intervention and, practically speaking, cannot readily accommodate it. The court should hold that the TPRA does not permit third-party intervention in this nature, or, at the very least, that the interveners here do not show the grounds required by Rule 24.02. First, the TPRA simply does not confer jurisdiction over intervening claims. The TPRA creates a claim. It says who the plaintiff is who can bring it. It says who the defendant is. And it says how that claim proceeds in the court. And it vests subject matter jurisdiction in the courts that they would not otherwise have. We know that because the Supreme Court said so in Tennessee versus Metro in 2016. And we know, generally speaking, that when you have a statute that creates a claim and vests that claim in a given plaintiff, that the court's power to adjudicate it is coextensive with the statute's grant of standing. The court only has the power to hear the claim on behalf of the claimant that the statute says. Here, and the Supreme Court said that twice in Osborne versus Marr and Lovelace versus Copley. And here, there's no provision in the statute that creates subject matter jurisdiction or creates a claim on behalf of parties such as the interveners. All it creates is this claim on behalf of a petitioner for public records. Therefore, third parties such as the interveners here don't have standing, and concomitantly, the courts don't have jurisdiction over their claims. And we can say all of that even withstanding the existence of Rule 24, because we know that Rule 24 doesn't alter the court's jurisdiction. The rules in general don't do that. The Supreme Court said that in 2016 in the Glassman-Edwards case. That the rules of procedure only tell the courts how to do the things they're otherwise empowered to do. But consider the issue from another angle. This court, just a few years ago, in the Monsieur case, Judge McClarty, with you writing, said that the TPRA bars discovery, as it is nowhere contemplated in the statute, and its plain language precludes it. That's just as true for intervention as it is for discovery. Certainly nothing in the TPRA provides for intervention. And the complication that intervention adds to a case is far more disruptive to the expeditious, simple proceeding the TPRA creates than the discovery mechanism is.
Mr. Krogh, let me ask you about, I want to move to some of the cases that we have. We don't have any directly addressing the issue of intervention, but we do have the Vanderbilt case where there was an intervener, although it wasn't discussed.
Correct, John.
So looking at that case, is it your position that in the Vanderbilt case, the Tennessean, that that particular intervener, the victim, should not have been allowed to intervene, even though the things that were potentially being disclosed were about her and directly impacted her?
Yes, Your Honor. Now, that's not to say that that victim shouldn't have been allowed to be heard at all. Certainly, there and in this case, the amicus mechanism would have been completely appropriate.
But do you agree there's a difference between having a philosophical interest in the case, like an amicus might, versus having an actual interest in things that are involving you, photographs of you, pictures of you? That's a different sort of interest than an amicus might have.
Well, certainly you can have amici in a case who have only a philosophical interest, but because the statute doesn't provide a mechanism for party participation, and there's not a legally cognizable claim that goes along with that kind of interest that you've identified, Your Honor, the best we have is the amicus mechanism. And that goes to why the interveners who didn't satisfy the requirements of Rule 24.02, because they don't have a claim or defense, right? What do we mean by that? It has to mean a legally cognizable claim or defense. And certainly that's the way the Supreme Court of the United States talked about that concept in a case called Amchem Products in 1997. Nobody here says they have a defense, but they do say that they have a claim in these TPRA exceptions and in the accompanying constitutional provisions. But there's no real authority for that. Right? You can't bring a standalone claim. You couldn't bring your own lawsuit to establish a TPRA exception. And even the constitutional privacy interests that the parents in particular invoke, the Supreme Court, our own Supreme Court, said in State versus Kaywood that those don't even establish an exception to the TPRA. So without something that you can say, that's a claim that you could bring in its own lawsuit, we don't have the basic prerequisite that the rule itself establishes for intervening. And so even though we can identify something that we can characterize, generally speaking, as an interest, a serious interest, and no one's saying that it
who
isn't.
really has a more vested interest than the subject matter of the disclosure?
Certainly they have a very serious interest, Your Honor, and I think so did the widow in the Griffin case, right? And the Supreme Court said it wasn't enough. And because there's nothing in the law that makes that a claim you could bring, now maybe it should be. If we were across the street, I think we would be having a very different conversation about what the public policy of this state ought to be. But this isn't a case about what the public policy ought to be. It's a case about what the statute says and what the statute requires. And in this context, there simply isn't a mechanism to provide the sort of relief that the interveners seek. Certainly the interveners should be able to file a brief. They should be able to make their position heard. But they shouldn't be given, because the statute doesn't provide for them to have party status as interveners. And in an analogous context, where you have a statutory claim like this that has a defined plaintiff and defined defendant under 820.101, the salary dispute claim statute, this court has twice said that intervention isn't allowed. The Shelby County Sheriff's Association versus Gillis case and Burris versus Wiseman both said that intervention in those contexts wasn't allowed for very similar reasons. You've got, the statute lays out who the parties are and what the claim is. And here, I think especially when you look at the expeditious, simple nature that this process is supposed to be, is there an exception? Government shows up, says what it is, proves it, and that's it. But that process is incompatible with adding in discovery. I think as the court rightly.
Well, no one's asking for discovery in this case. I guess my question is, what is the great harm in allowing another voice to be heard, whose voice may not be adequately represented by the existing respondent? How does that harm the judicial process in any way?
I think in largely the same way that discovery would, it derails and complicates what the legislature has said is supposed to be a very simple, straightforward process. You know, it's a little bit like that old college gag of how many people can you fit in a phone booth. Well, I don't know exactly what the answer to that is, but I know if you try, it's probably pretty hard to make a phone call. And here we have practically enough attorneys in this case now to hold a business meeting in the Bar Association. And the idea that we're going to go in and have this expeditious, very simple process in which Metro is going to say, here are the exceptions and here's why they apply, and we're done, I think with the interveners is gone. Because when we've got expert reports in this record now, and we're going to have side litigation on the Brown-McDaniel factors in this simple expedited case, that's not compatible with what the legislature told us to do in these cases. What we have, and of course we have we always have the safeguard of the court, right? The judge, ultimately the chancellor, and then this court, if need be, is going to look at those documents and determine which one of them comes out, which ones of them come out, and which ones don't. And so it's not as if you have to rely only on the government attorneys in a case like this. You've always got, as you do in any case, the stopgap and the safeguard of the court itself, which is going to review the documents in camera. And of course, the interveners don't have the documents, right? In most cases, they probably will not ever even have seen them. And so for those reasons, Your Honor, we submit that the trial court committed an error of law and its decision should be reversed.
Thank you very much. You have your time for your rebuttal for the appellee.
Good afternoon, and may it please the court. My name is Rockland King, and I represent the Covenant Presbyterian Church. On March 27th, 2023, a church, a school, and a group of families suffered an unspeakable tragedy. The trial court ruled that this church, this school, and these families can be heard in the Tennessee Public Records Act litigation that is now ongoing on whether the documents collected from this tragedy are discoverable under that act. That decision was not abuse of the trial court's discretion and should be affirmed by this court. The appellants encouraged this court to find that the TPRA makes no room for intervenors and cannot accommodate their presence in this litigation. The appellant's argument, however, finds no support in the text of the TPRA or how our Supreme Court has interpreted the TPRA in permitting intervenors to not only intervene, but argue their position in front of the Supreme Court of this state. The text of the TPRA does modify some of the traditional rules of civil procedure that we've all grown accustomed. It abolishes the Rule 8 requirement for responsive pleadings, does away or limits discovery, or at least according to the Monser court case, leaves that to the discretion of the trial court and provides for an expedited resolution of the claim. But what the Tennessee General Assembly did not do is it did not include divestiture language in the act. It did not divest expressly a trial court of its discretion to permit intervention. And that is important, Your Honors, because the General Assembly did modify how the rules of procedure apply to this type of civil action, but it chose not to modify Rule 24's application. The General Assembly had every opportunity to write into the TPRA that there shall be no intervention, just like it did when discussing Rule 8 responsive pleading, but it elected not to do so. And that demonstrates that the General Assembly chose its words carefully. And what the appellants encourage this panel to do is to write the statute to include that divestiture language. But as this court and the Tennessee Supreme Court has held many times, it is not for this body, but rather for the General Assembly to write the statutes. And we grow confident in this position when we look at how the Tennessee Supreme Court has twice handled the issue of intervention. Twice, in 1991 and then again in 2016, the Tennessee Supreme Court heard from an intervenor. In 1991, it heard from a widow of a state representative who committed suicide. The suicide note was collected at the home and was taken into custody. The widow argued and intervened in the trial court, and then in the Court of Appeals, and then ultimately to the Supreme Court, that this document did not constitute a public record. The Supreme Court squarely addressed her arguments and its holdings. Then again in 2016, in the Vanderbilt trial, in the Tennessean case, the victim there intervened. And again, the victim was heard by the Tennessee Supreme Court. And again, the Tennessee Supreme Court addressed the victim's argument in its holding. These cases are demonstrative that the TPRA does make room for an intervenor.
Let me ask you this. In this case, what is your particular client's common question of law or fact with the claim or defenses presented? Because that's the language we have to travel under.
Yes, Your Honor. So the church and school operate at the same premises. The Covenant School operates at the Covenant Presbyterian Church. Thus, all security information, schematic information involved in this case is actually owned by the Covenant Presbyterian Church. And as the institution that hosts that school, we're traveling under the school safety exception under 504P of the statute, which provides that school schematic information, safety security information, shall not be subject to public disclosure. So that is the common interest and claim that is being advanced by the school and the church in this respective case. And Your Honors, when we look at the threshold inquiry of whether there was a common claim being advanced, that threshold was satisfied. And when we look at the text of the TPRA and how our Supreme Court has interpreted that text, they have permitted intervention. This makes clear that there is room within the TPRA to hear from interveners. And it further makes clear that there is subject matter jurisdiction for interveners to participate. Thus, it was not an abuse of the trial court's discretion to grant intervention. And we ask that this court affirm that decision. Thank you, Your Honors.
Thank you.
Good afternoon. My name is Eric Osborne. I am here on behalf of the parents of the Covenant School children, together with my colleagues from Sherrard Rowe, Voight & Harbison, Spencer Fane, and the Howe Hardin Law Office.
Thank you. You may proceed.
Thank you, sir. We represent over 100 families, including the families of all 6 homicide victims that day, and approximately 200 children that are just terribly at interest right here. No one has a greater interest in what is going to happen in this case, I would submit to you, than the Covenant School children and the parents who are acting on their behalf. In my time today, I want to try to cover 3 issues. I want to talk about the parents' personal stake in this case, because personal stake is what, in the Shelby County case, the court found was important for someone to be able to intervene. You had to have a personal stake, and you had to have standing. The trial court correctly found that all interveners have both a personal stake and standing. I want to talk a bit about why the Chancery Court exercising its discretion is proper and how important that is, that trial courts continue to be able to exercise their discretion under Rule 2402. And then if I have any time left, I want to go through the bases for intervention, because in the end, under the standard, as long as there is a basis in law or fact, then under the abuse of discretion standard that is applied, this court should affirm the trial court. So those are the 3 things that I want to try to cover, but those are the 3 points that I want to make sure get made, and I appreciate that, Your Honors. Let me talk about the parents' interest, because I just cannot emphasize enough that for the parents, this case is literally a matter of life and death. And I don't say that lightly. I really don't say that lightly. Before the case was stayed, we had a comprehensive and full and complete record. This court stayed the case on the eve of the show cause hearing. At that time, the parents had submitted approximately 25 declarations And in our brief, we asked that the court please read those because I cannot do justice to these declarations about what these children have had to go through since March 27th. We also submitted declarations from prior school shootings in which parents talked about what happened from prior school shootings. And we submitted the expert report of Dr. Erica Felix, whom NPR refers to as the greatest expert in the world on childhood mass shooting trauma. Now, what together the evidence shows is simply a grim picture of what the kids have been going through and what they are likely to face. But it particularly shows that the release of documents will only aggravate and grow their psychological harm. And in particular, I want to emphasize one thing, and I have to emphasize that I hate to even say this because I'm giving voice to something that every parent fears deeply. But the simple fact is that the record that we have presented shows that there is a very real risk that if the shooter's writings are released, one or more children may harm themselves. It has happened time and time in the past from school shootings, and we have a unique opportunity here to try to prevent these writings from coming out, to try to protect these children. That is the personal stake that the parents have, and I cannot think of a greater and more powerful personal stake or interest that any party could come to. And I want to also emphasize, because again, you have the complete record before you, that the petitioners did not argue any of this. They put up an expert who dealt with one side issue about whether or not a school shooting documents being released can lead to a copycat, but they did nothing to rebut the reams of evidence that the parents put in about the harm and trauma that the kids would suffer. And so we come to this appeal with a record that I would argue establishes just an immense level of harm that 200 Tennesseans might face for the rest of their lives. And all we ask is that we be able to make our argument. That's all we're asking for. We're just here on intervention today. We're not even here on the merits. And yet the petitioners want to say that we can't. Now I see I have just 1 minute left, so I want to just briefly say that the trial court was correct in finding that we had a personal stake. The trial court was correct in finding that we had standing. Discretion, I mentioned earlier, is an important part of the rules of civil procedure. In the Ballard case, the Supreme Court said that it is very important that trial courts continue to have discretion under Rule 2402, including in the matters of intervention. The trial court here exercised its jurisdiction, and the fact that in this particular case that involves one of the worst crimes in Tennessee history and 200 children whose lives are at stake, the trial court decided to permit intervention does not mean that intervention is going to become some huge chronic problem in TPRO cases going forward. Trial courts are the gatekeepers, and they can decide and will decide in the future that there may be cases in which people should not intervene. But respectfully, in this case, the cause for intervention is the greatest one can imagine. I really appreciate your time. Thank you for hearing from me today.
Thank you, sir. Now, next, Appellee.
May it please the court, I'm Laura Fox, representing the Metropolitan government.
Yes, ma'am.
The appellants are mistaken when they argue that the Tennessee Public Records Act sets up a bilateral process between a requester and the government. It sets up an extremely multilateral process, and let me explain why. There are hundreds of exceptions to the Public Records Act, and almost all of them are for the benefit of a private individual whose information should not be released by the government. All of these exceptions, what is the meaning of any of these exceptions? There is none if the private person could not participate in a lawsuit where their personal photographs, if it was a crime, their personal social security number or bank accounts, their trade secrets or proprietary information, all of that comes into the government's possession, some of it because you make an application for a government service, some of it here where you have a victim of a crime. And the idea that there would be no voice for all of those exceptions is not correct. That's just simply not what the statute envisions. The statute envisions that the government would have certainly the first crack at looking at whether there's exceptions, but we have no case law saying that it is the only crack or that anyone who this exception has purposefully been designed to benefit should not have a voice. And in the Tennessean versus Metro case, which I argued, it wasn't just the victim who was allowed to intervene. It was also the district attorney in the state of Tennessee. There are many entities who have an important interest in all these public records cases. Now, I agree that it is not going to be a situation where every public records request turns out to become a 2-year process. I've been at Metro for 23 years, and I've had probably 4 cases that went to a lawsuit out of public records requests. But there are hundreds of public records requests that are fulfilled every day by the government without having any kind of intervention. So it's not going to slow down the process. But when there is such an important interest in protecting private information, that person is absolutely allowed to be heard. I am the government attorney. I do not represent these families. I do not represent the school whose safety is part of the exception, or the church. We have an actual conflict in the position that we are taking in this case, because at the end of the investigation, Metro believes that under existing case law, the criminal investigation mostly becomes a public record. The families say no, under the exceptions that they assert in their constitutional right. They argue that that none of the investigative files should become a public record. And so not only do I not represent them, but Metro has a different position than the victims in this case. That's wrong under the law to not allow them when there is a common question of law and fact. And the question is, what is the scope of the exceptions in this case? Of course the families can intervene. They need to be able to not just file an amicus brief, but they need to be able to file motions, submit declarations, and be able to guide the case in the event that the government is taking a different position. Metro's brief is slightly different than the family's briefs, because we do talk about the many cases where the newspapers have intervened in cases where they had no relationship to the parties. In the Ballard case, it was a private lawsuit, and there was matters under seal. The newspapers asserted that is a public record. We should be able to intervene in that lawsuit and participate in that lawsuit, and it's been routinely granted when it comes to participating in the lawsuit on behalf of the newspapers. But here they assert that the families, or whoever is the private individual who's not going to, whose matters are not whose private information is about to be shared, should not be able to intervene. This is an ongoing criminal investigation, but that criminal investigation will end at some point in the relatively near future. The school safety exception has been asserted. The school and the families who are the victim at that school are allowed by law to participate, and we ask that the trial court's decision be upheld.
Thank you very much.
Thank you.
For the appellant.
Thank you, Your Honors. The arguments that my friends on the other side make are almost entirely and transparently policy arguments. They describe interests, compelling policy interests, for why the court should let them intervene in this case. And they don't ever articulate, here today or in their briefs, how any of those interests are reflected in a cognizable legal claim. Now, maybe a claim ought to exist. Maybe we all think that very deeply, and no one can point out what it is because it doesn't exist. The claims that are in cases like Ballard, on the other hand, do. There is a standalone, independent claim for access to judicial records. Right? And if you didn't have Rule 24, you could bring that claim as a standalone mandamus action and name the clerk of the court as the nominal defendant and the parties to the protective order case as the real parties in interest, and you could have that as a standalone lawsuit without Rule 24. Those cases are completely different and shed no light, except in support of the petitioners, on this case. My friend, Mr. King, said that Griffin and the Tennessean make clear that intervention is permitted in cases like this. They don't say that at all, Your Honor. No one challenged the intervention in those cases. And our Supreme Court and the United States Supreme Court have said on numerous occasions, going back to the 19th century, that when we don't decide a thing, you can't cite the case for that principle. Or even if we overlook an authority that ought to have controlled, you can't really cite the case for that principle going forward. So those cases don't shed light here either. And it might be that maybe the parties in that case, in those cases, didn't make an issue out of it because there wasn't Rule 24.05 then. Right? You couldn't take the immediate appeal. You had to wait till the end to raise it, and maybe there it wasn't worth it. I've tried to find the briefs in Griffin, incidentally, and I think the feds impounded them as part of that investigation. But certainly there's nothing in the Tennessean briefs about this issue. It's not addressed in the opinion. It's not an issue that was decided. It's not part of the holding in those cases. On the question of jurisdiction, we don't have a case on the jurisdictional issue directly on point here in Tennessee. I found, getting ready for today actually, that Michigan does. Michigan has a similar statutory standing jurisdiction rule as Tennessee, and they have twice held that that rule prohibits intervention. A case called Estes versus Titus, 481 Michigan 573 from 2008. And there's a 2017 Court of Appeals case called Council of Organizations and Others for Education, 751 Northwest 2nd, 493.
Are these cases cited in your brief?
They aren't, Your Honor. I hadn't discovered them until now. I'm happy to file a 27D letter.
I would suggest that you send the citings of these cases, a copy of that to the clerk, and let her forward those to us, or you can send them directly to us. Do not argue the case, but just send us the citations of the case.
Certainly, Your
and
Honor.
we will look at that.
Certainly, Your Honor. My friend Mr. King also mentioned that the legislature has chosen not to modify Rule 24 in the statute. Respectfully, Your Honor, that's not how statutory interpretation works. It's certainly not the line of reasoning the court took in the Monsieur case. This isn't a case about whether or not these parties should have a voice. It's only a case about whether or not the court can depart from the text of the statute to give it to them in a way the legislature has not provided. Respectfully, the judgment below should be reversed. Unless the court has any other questions, I'll thank you for your time.
I hear none. Thank you very much. That would conclude our oral arguments. If there's nothing further from the court, Madam Clerk, I ask that you would please adjourn court to the next calling of the docket.
All rise. This court stands adjourned.